Hello, and welcome to Administrative Remedies, because you can't fix what you don't understand. Brought to you in part by the University of Tulsa College of Law. I'm Gwendolyn Savitz, an associate professor here at TU and the associate dean of research and intellectual life.
And I'm Mark Rourke. I'm the dean of the College of Law.
We'll be breaking down complex doctrines with real-life analogies and examples to demystify the world of administrative law for everyone trying to understand how government actually works.
Agencies are the main way the federal government gets things done. It's not through Congress, for reasons we'll be addressing over the course of this series.
All right, let's pick up where we were when we were talking about immigration. Picture a visitation room in a private detention facility in rural Louisiana. We've got Cinderblock walls, fluorescent lights, 2 plastic chairs bolted to the floor on either side of a metal table. We have Elena on one side and a lawyer who drove 3 hours from New Orleans on the other side. They have 90 minutes. Elena has 8 months until her merits hearing. Then that's the hearing that decides whether she gets asylum or is going to be sent back to Honduras. In those 90 minutes, the lawyer needs to learn her story, identify the social group theory, figure out what corroborating evidence exists and where, and explain to her what's about to happen. And the lawyer, this is a long drive, probably won't be coming back for at least 6 weeks.
And the evidence she needs to prove her specific case, that's all back in Honduras.
Right. So there's going to be some stuff produced by our government that's available to everybody, but what won't be available is the stuff that was specific to her. The neighbor who saw the assault, the death certificate, the medical records from a clinic in town, the threats that came in over the phone. The evidence is in a country she fled, in a town she potentially can't safely call into, and would have to be gathered by family members who themselves might be at risk just from gathering it. None of that's in the visitation room.
Okay, so last time we walked through the machinery, the backlog, the asylum framework, the AG certification, Jackler and at-will immigration.
Yeah, so today we're looking more at one person inside that machinery because judge assignment definitely matters. It's a huge factor, but there are a couple of other huge ones. One is whether you have a lawyer, and the other one is whether you're in detention while you're trying to put your case together.
Okay, so 2 more, representation and then detention.
Right. So on both of these, immigration is harder than anywhere else in the federal system. Representation drives outcomes everywhere in adjudication. We already talked about that with Social Security, but there are a couple important differences here.
Like what?
Represented asylum seekers win at several times the rates of unrepresented ones in non-detained cases. And if they're detained, which we're going to be talking about soon, that representation rate matters even more. Unrepresented denial rate can be 90%.
So several times the rate, we're calling that the same adjudication system?
Yeah, the doctrine doesn't care whether you have a lawyer, but the outcome can care enormously.
So the type of adjudication?
This was comparing immigration hearings to Social Security hearings. Remember, Social Security hearings, we had an inquisitorial judge model where the judge was supposed to be helping develop the facts. Immigration hearings are adversarial. So there is a DHS attorney across the room, a government lawyer whose job is to present the case for removal, to cross-examine the respondent, and to argue against asylum. So in Social Security, there's no opposing counsel. Again, the judge is supposed to be helping develop the record. But in immigration, an unrepresented immigrant doesn't just lack a lawyer, they're actively facing a lawyer.
And often they're not going to speak English.
Right. And then things get even worse because now they'll be answering questions through an interpreter. And they'll be doing it about traumatic events while government lawyers trying to find inconsistencies in their story. And that translator alone can introduce problems. So the witness might say one word in Spanish, and the interpreter might say a slightly different variation that might be different than what a previous interpreter said. And the DHS attorney can pull the credible fear transcript and accuse them of changing the facts because now there's a contradiction in the record. So the respondent doesn't know what happened, and the judge has to decide whether that inconsistency is because of their credibility or because of translation issues.
And with a lawyer in the room representing the immigrant.
So if we have a lawyer in there doing this, the lawyer can object. The lawyer can ask the interpreter to clarify. They know what was in the original transcript. They can help make sure that if they're really trying to say the same thing, that that's clear to everybody in the room. They can redirect on the alleged inconsistency, and they can help put the credible fear transcript in context. Without a lawyer, the respondent is sitting next to an interpreter that they can't evaluate, listening to questions they didn't anticipate, with a government attorney building a credibility case in front of a judge who has 3,200 cases waiting. That's the room we're in.
In a criminal courtroom, somebody would have been appointed for her by now.
Right. But unfortunately for her, in immigration cases, there's no right to appointed counsel. So the Sixth Amendment right applies in criminal cases. Immigration removal is considered a civil procedure. Respondents have what the statute calls a privilege of counsel at no expense to the government. They can hire a lawyer or they can try and find a pro bono one, but the government will not be providing one. If you can't afford one and the pro bono organizations in your area are full, you're going to be representing yourself.
Against a trained government attorney through an interpreter in front of a judge whose grant rate may be 4%.
Right. And again, the stakes of losing here aren't loss of a benefit. They are removal to the country that this person originally fled. That's the line that separates immigration from every other adjudication system we've covered. In disability, losing means not getting benefits. That's devastating. It really is. But the claimant is still staying here. In immigration asylum cases, losing means going back to the country you're saying you fled because you had a well-founded fear of persecution there. The risk that your asylum claim was actually correct and you will be in major danger if you return is the consequence of getting the answer wrong here.
So the premise of an asylum claim is that the country is dangerous to this person. The consequence of denial is returning them to that country. So we're building an adjudication system whose error costs in one direction are exposure to the persecution we said we don't want to expose people to.
Yes, so that's the structure, and the Supreme Court has said it's constitutional.
It would seem like those are pretty high stakes, though. I mean, life and death, sometimes literally, should trigger more procedural protection, not less.
So that could be the intuition, but the doctrine very clearly cuts the other way. The Constitution's procedural floor for immigration cases is lower than the floor for someone losing Social Security benefits.
Wow. Right. Goldberg v. Kelly says you can't terminate welfare benefits without a pre-termination hearing. We've talked about it 3 or 4 times this season that welfare, cash assistance, the court treats it as serious enough to demand a real hearing with confrontation rights before the government takes it away. And asylum, where the alternative is removal to a country we've conceded may persecute the person, gets less.
Yeah, less and not by a little. So there's 2 reasons for this. They're both still good law. The first is plenary power. So if we go back to the Chinese exclusion case in 1889, the court held that Congress's authority over who may enter the country is something close to absolute. It's largely beyond the kind of constitutional scrutiny that would apply to almost any other federal action affecting someone this seriously. And the court has continued to chip away at this over the decades, but it's never overruled the foundational case. That doctrine is still the starting point.
So what's the second?
All right, this is the line between people inside the country with established ties and people seeking entry. Someone who's been here for years, who's working, raising kids, gets more due process protection than someone who's apprehended at the border. There's a recent landmark case. It was Asylum in 2020. So here, the respondent crossed the southern border. They were apprehended within 25 yards. They sought asylum and they were placed in expedited removal. The court said that there's essentially no due process right to judicial review beyond what the statute provided.
25 yards inside the country, but the Constitution treats him as if he's still outside of it.
Functionally, yes. So the court's treating recent unlawful entrants seeking initial admission as if they were standing at the border. Whatever process Congress gave them by statute is the process they get. Here's the key part.
Okay, as applied in this case, the statute, which limits the habeas review obtainable by non-citizen detained for expedited removal, does not violate the suspension or due process clauses. So a statute restricting habeas review for someone 25 yards inside the border doesn't violate due process. That's the holding.
Right. So that's what it meant in 2020. And the administration is testing how far that distinction can stretch.
Stretch how?
So January 2025, there was an executive order that directed DHS to expand expedited removal to anyone anywhere in the United States who can't prove they've been in the country for more than 2 years. Before that, the agency had limited expedited removal to people who were apprehended within 100 miles of the border, which is still way more than 25 yards, but way less than the whole country, and within 14 days of entry. So this 2025 expansion took it to anywhere in the country and stretched the entry window from 2 weeks to 2 years.
So, to Racism's logic, 25 yards from the border, treated as it's standing outside the country is being applied to someone picked up in a workplace in Ohio who has been here for 23 months.
Right, assuming they're undocumented. When this was issued, the D.C. District Court enjoined it, and the D.C. Circuit declined to stay the injunction. The panel said the government wasn't likely to succeed on the due process question.
And the underlying question is exactly the one we just walked through. How far inside the country does tu racisme essentially have no due process protection? And how far does that rule reach?
Right. That's the question. And for now, the D.C. Circuit has said not all the way. There is some line, and someone who's been physically present in the United States for months or even years, who's been building a life, is on the protected side of it, even if they entered unlawfully.
So there's at least some procedural floor still, even if it moves opposite to the stakes. Higher stakes create a thinner floor, but that's an inversion of what most people would assume the Constitution does.
Right. That's potentially counterintuitive, and there's also another recent shift. So the plenary power goes back to 1889. Goldberg was decided in 1970. The courts had decades to try and bring these two lines of cases into agreement, and it hasn't.
Okay, but plenary power isn't just doctrine. It tracks a serious view that controlling entry is a sovereign function and that people who arrive without authorization aren't entitled to the same procedural package a citizen gets. Someone who thinks no one should be allowed in without going through the legal process listens to this episode and says, fine, the system is harsh. That's the design. Asylum is generous on the margin. The Constitution lets Congress draw the line where it draws it. What do you think about that?
That view is definitely real, and it is held in good faith by a lot of people, and it eventually has constitutional support under what the court said. That's basically the whole idea of plenary power, but you don't have to think the doctrine is wrong to be upset by what's going on. The question we're looking at is narrower. It's given the statute that Congress wrote, which does grant asylum, which sets up the adjudication system, which promises individualized hearings. Is the system actually delivering what the statute says it should? You can think the statute should be narrower and still want the adjudication under the existing statute to be accurate. Strict or generous, the law is supposed to apply the same way to the same facts. That's not a policy claim, that's a rule of law claim.
So the critique works regardless of where you stand on how many people should be admitted.
Right. If you want fewer grants, you want the denials to be the right denials. If you want more people in, you still want the people admitted to be the right people. Either way, you want the adjudication to track the law. That's the thing the data says isn't happening reliably. All right, so let's come back to Elena. She was picked up at the border. She was placed in expedited removal after she passed her credible fear interview, and she was transferred to this detention center in rural Louisiana. Her 8 months in detention run inside that facility, which means she is definitely not preparing her case from her apartment.
And SSA disability claimants aren't detained while their cases are pending.
Right, they're not detained, period. Immigration respondents often are. And that's a feature of the system here that has no analog anywhere else in administrative adjudication.
How long are they potentially incarcerated for?
For asylum cases, it could be months, if not a year or more. Sometimes they're going to be in multiple different facilities. They might be picked up in one state, transferred to a facility in another, occasionally to a third. This was true before Trump started doing funny stuff with immigration, too. This has been like the way the system works. They might have family in Houston, a lawyer in New Orleans, and the detainee, best case scenario, if their lawyer's in New Orleans, is in Gwen, Louisiana. None of that's unusual.
And before the merits hearing, there's a separate proceeding about whether they can stay there.
Right. So this is the bond hearing, which can have a huge effect on how the merits hearing will go, but doesn't get a ton of attention. So Elena's bond hearing would have happened by video, like the third week she's in custody. The IJ is in an office in Texas. The DHS attorney is on another video feed, and she's in a small room in the facility with a chair bolted to the floor. She has no lawyer at the bond hearing. She probably hasn't been there long enough to get one, and the whole proceeding can take like 10 minutes.
So 10 minutes to decide whether she prepares the merits case from the inside or the outside.
Right. And this itself is an IJ proceeding. So we're going to have the same judge pool, the same variation, and the same constraints. What the judge is deciding isn't the asylum claim. It's whether the respondent is a flight risk or a danger and what bond amount, if any, would secure release. So the factors are things like community ties in the U.S., criminal history, prior immigration violations, sponsors who can house her, Elena here has been here for 3 weeks, and she might have a cousin in Houston that she's spoken to twice, but at this point, she potentially doesn't have any documents to put in front of the judge proving that the cousin exists.
So a respondent who wins bond prepares for the merits hearing from the outside. A respondent who loses bond or can't post it,
they're going to be preparing from inside. These two are wildly different cases by the time they get to the merits hearing months later. The respondent on the outside can meet with the lawyer in the lawyer's office. They can gather documents with family. They can contact witnesses overseas through free methods like video chat. They can sit through preparation sessions. Well, somebody who's doing it on the inside is probably in a rural location with a few sporadic legal visits, trying to mail documents and communication through monitored phone calls. Same statute, same asylum framework, but a completely different ability to present it.
And there's an empirical handle on this as well.
A significant one. Detained respondents are represented at a rate well below half of non-detained respondents. And among the detained respondents, the gap between represented and unrepresented is wider than any other population that people have looked at, by an order of magnitude in some cases. So detention compounds every variable. You're less likely to have representation, you're less likely to be able to develop good evidence, and on this rocket docket system, you've got less time to develop it too. And when the merit hearing happens, it's based on whatever you've managed to assemble by that time.
Okay, take Elena. 8 months on the rocket docket is brutal, but maybe workable from outside. But 8 months from within inside a Louisiana facility.
Right, that's going to be something else entirely. And 8 months passes the same way either way. And a judge isn't going to grant a continuance because a respondent is detained. That's not a basis for one. A detained Elena's clock is the same as a non-detained Elena's clock. But what she can do in those 8 months, meet with a lawyer who can travel to her, get her family to ship medical records from Honduras, find an expert on country conditions. This can potentially collapse. The rocket docket plus detention is the worst combination the system produces. Fast hearings based on thin records, and the thinness isn't necessarily because the person didn't try.
And the kind of evidence asylum requires, what's happening in the home country right now, is the kind of evidence that's hardest to gather from inside a detention facility.
Right. So the State Department has country reports that are public. Her lawyer can pull those, but the case-specific evidence, the affidavits from people who witnessed the persecution, documentation of the threats that might have targeted her family, expert testimony about whether her social group theory matches actual on-the-ground conditions, that's evidence that can depend on somebody outside the facility doing the work. If she has a lawyer, maybe there's someone who could do that. If she's pro se, the evidence often doesn't make it into the record at all. And then the judge, who is required to consider current country conditions, decides on a record without the current country conditions that would have supported her claim.
Okay, so the legal standard says current conditions control. The detention reality says the respondent may not be able to put those conditions in front of a judge.
Right. The judge is just going to be deciding based on the record the parties submit. Detention does not just change how the case feels, it changes what evidence exists in the case. So 2 respondents with identical claims, if one's detained and one's not, can arrive at the merits hearing with materially different records. That's structural variation, that's not individual failure.
Okay, let's put the IJ on the other side of that. The judge in that courtroom is looking at a detained, unrepresented respondent, making a record on the fly through an interpreter against a DHS attorney building a credibility case. The judge has 3,200 other cases waiting. What does that hearing actually look like from the bench?
Some of the variation we can see in judge claims is because some IJs will do some factual development on their own. They might ask the kinds of questions that a lawyer for the immigrant would have asked. They might leave the record open for additional submissions or push the DHS attorney on whether something is actually in dispute. But other IJs treat the adversarial system as though it is strictly binding. If the respondent doesn't raise it, it isn't raised. If the corroborating evidence isn't in the record, it isn't in the record. Both of these theories are defensible, but they produce different outcomes. So again, that helps explain some of the variation in judges, although not all of it.
So go back to Elena in the visitation room. 90 minutes, a lawyer who drove 3 hours, evidence is in Honduras. That's the 8-month version of the case.
Right. And if she's pro se, she's not going to be in a visitation room. She'll be trying to work on a tablet in a common area or a phone in a booth with a list of legal aid organizations she can call. and voicemail she can leave that may or may not be returned, and the docket clock is running.
So the structure we've been describing, how did this become the system?
Well, incrementally. Immigration adjudication has never been housed in an independent tribunal. Since the Executive Office for Immigration Review was created in 1983, immigration courts had been part of the Department of Justice. The AG has always had certification authority. But what's changed over time is how aggressively these tools are being used and how much political supervision is brought to bear on case outcomes.
And there's a long-standing proposal to then change that structure.
Right. So people have tried to push for an independent court with independent judges who would have tenure protections, or at least some protections, like magistrate judges do, who would have appeal to a similarly independent appellate body and further review by Article III courts. And this has been endorsed by the American Bar Association. The Federal Bar Association's immigration law section has pushed it. There have been various bipartisan groups working on it, but no bill has ever passed.
Why not?
Well, Congress is bad at acting on almost anything, but immigration is one of the worst areas. The last major immigration legislation was passed in 1996. So we've had 30 years. Everyone who studies the system agrees the structure is the problem, but the structure stayed the same.
So the system we've been describing is likely the system that will exist for the next 10 years.
Right, which means we'll continue to see the patterns we've been talking about on some of the highest stakes adjudication systems in the federal government for as long as the political economy of structural change makes it unfeasible.
What about Rosa and Elena? Where are we leaving them?
All right, so Rosa is at home in 2026. She's potentially working with a permit. She has a 2028 merits hearing on the docket. At that point, she'll be doing it based on 6-year-old evidence, and the rules could have changed to something that's less favorable. SSFM, that's what we were talking about with her. That's the negative. That's the result that's going to hurt her. That's probably still going to be the law in 2028. But if we could contrast that to Elena, if she'd really crossed in 2022, she would have had her case decided in 2022 or early 2023. So there's a chance she would have been allowed to stay. She had a lawyer, so that would have helped. But given how quickly things were moving and the constraints she was facing, she probably would have been sent back. So on paper, this is a system designed to produce fair adjudication. Due process, appellate review, neutral decision makers. The paper version does not match the operating system. In immigration, the variation is wider, the independence is thinner, the stakes are higher, and the pressure on the adjudicator is more direct.
And the people caught in that have the least ability to affect it. They may not speak English, they may be detained, they may not have a lawyer, their case may turn on a doctrine that changed after they all filed, and before a judge whose grant rate looks nothing like a judge down the hall.
Right. The same pressures we've been talking about for a while at this point.
And the question we keep arriving at is the same. The agency is doing what it's doing, the doctrine has narrowed, the variation persists. What can anyone do about it from the outside?
Yeah, this is where the question starts to shift. So once a system is producing outcomes this uneven, under pressure this direct, the next issue isn't what happens inside the agency, it's what courts do from the outside.
And I'm willing to bet that's less than people think.
Excellent guess. So courts review based on the record the agency made and under standards that the agency generally benefits from. They don't reweigh credibility. They don't get a second look at country condition evidence that the respondent didn't put in front of the IJ because they were detained and couldn't get to it. By the time a case gets to the circuit court, the record is what it is. So judicial review is real and it matters, but it's also not the rescue mechanism people sometimes imagine.
Which is where we're headed next season.
Yes, so next season is judicial review. What happens when the stuff finally goes to court? We'll start with the basics on justiciability. That really matters in admin cases. Most of the justiciability cases are admin cases before we get to standards of review, and we'll be starting that mid-July. But before that, we will do an episode to officially acknowledge the death of Humphrey's executor once it's announced, and that should come down sometime in June.
So that does it for today's episode on Administrative Remedies. Thank you for joining us today. Please, if you enjoy this podcast and enjoy this episode, give us a like on Spotify, iTunes, or whatever platform you're listening on. And be sure to tune in next time where we'll continue to dive into the contours of administrative law because remember, you can't fix what you don't understand.